The case of Sveen v. Melin is a case about the Contracts Clause of the Constitution. Contracts Clause says that no state shall pass any law impairing the obligation of contracts. And at issue is a 2002 Minnesota law that said that in the event of a divorce, the designation of an ex-spouse as a beneficiary will be revoked automatically. Kay Melin and Mark Sveen were married in 1997. They get divorced in 2007. When Mr. Sveen died, the primary beneficiary on his life insurance policy was his ex-wife, Karen Melin, and the contingent beneficiaries were his 2 children from a prior marriage. So the question is Kay Melin still the beneficiary, or did the law operate to make his 2 children from a prior marriage the beneficiaries? I don't think that the outcome of Sveen v. Melin surprised anyone. The children win. Justice Kagan says that there was no substantial impairment of the insurance contract by the Minnesota law, because basically the law just reflects what the likely intent of a policyholder would be upon getting a divorce. The dissent by Justice Gorsuch is interesting because he says, look, the Contracts Clause doesn't say only substantial impairments trigger the protection of the Constitution. It says any impairment, right? And so that's not a part of the original constitutional protection as a matter of text, as a matter of original public meaning. The idea behind that dissent is to sort of revive the Contracts Clause as a valid constitutional provision for analysis.
In Lucia versus Securities and Exchange Commission, an administrative law judge found that Mr. Lucia had violated various investment-related regulations. Congress, by statute, had already given SEC commissioners the authority to appoint ALJs. But the SEC commissioners had decided on their own to delegate that power, and so it was really staff within the SEC who had signed on the dotted line of the ALJ's appointment. Mr. Lucia said that violated Article 2 of the Constitution. Therefore, the ALJ was never appropriately exercising governmental power in the first place and could not impose that penalty on Mr. Lucia. The Supreme Court reconfirmed that the Appointments Clause is an important mechanism for accountability within the executive branch. Administrative law judges who oversee formal hearings within administrative agencies are officers of the United States who need to be appointed by either the president or a department head or court of law, which gives accountability back to the people to know who put in place administrative law judges who are carrying out important decisions with great weight for members of the American public.
Animal Sciences versus Hebei Welcome Pharmaceutical involves a lawsuit brought under Section 1 of the Sherman Antitrust Act, alleging that 4 Chinese vitamin C manufacturers were fixing prices on vitamin C exports into the United States. That case was tried to a jury, and the jury rendered a verdict of $147 million in favor of the plaintiffs, finding that the Chinese companies had in fact engaged in price fixing. Very interesting thing happened. The Chinese Ministry of Commerce filed an amicus brief, and their amicus brief stated that Chinese law required the Chinese governments to charge the prices that they did. The Federal Rules of Civil Procedure 44.1 says, whenever a U.S. District Court is confronted with an issue of foreign law, it shall treat that question as an issue of law, not one of fact, and it can consult whatever relevant materials or sources it feels it needs to. So the Second Circuit says, well, we think that if a foreign government intervenes and says that it's their law, that we have to defer to it so long as it's reasonable. Supreme Court opinion by Justice Ginsburg remanded to the Second Circuit and essentially said conclusive deference is wrong. You can still say that Chinese law is what the Chinese government says it is, and you could still reverse the jury verdict, but you have to look at the representations that are made.